Hello, everyone. I'm Kristi Arcurie, a Senior Client Success Manager here at G&A Partners. Thank you for joining us today. We have two leading experts joining us to dive into a topic that can be a major source of liability for employers, employee accommodations. Desiree Stevens and Kimberly Gray are employee accommodation experts who help G&A clients with these issues every day. They're going to walk us through the fine print of compliance and how to respond to employee requests with confidence. After all, a single mishandled request or paperwork oversight can quickly escalate into a costly legal proceeding, especially for small and mid-sized businesses. Today, you'll learn about the scope of workplace accommodations and why consistency matters, real-world scenarios where small businesses fell short and how you can get it right, how to build a bulletproof, documented process for requests, and last but not least, the impact of an inclusive culture on morale and business objectives. This webinar is a highly practical conversation. Our goal is to provide you with actionable steps you can implement immediately to protect your business and your people. If you have questions throughout the presentation, please submit them in the Q&A feature. We'll save time at the end to answer as many as possible. Before we begin, just a couple of quick notes. This conversation is solely focused on W-2 employees, not contractors or gig workers. And what we share here should not be taken as legal advice. Now let's get started. Desiree and Kimberly, can you both introduce yourselves and share a bit about your background working with employee accommodations?
Sure. My name is Desiree Stevens, and I'm an HR advisor on G&A's Leave and Disability Administration team. I actually started my career out in staffing and moved into the employee disciplinary action piece of it, as well as leaves of absences on the staffing side. And I have actually been with G&A for 7 years now. And I've been with the leave of absence department for about a year now.
Awesome. Thanks, Desiree. Kimberly?
Hi, I'm Kimberly Gray. I have over 25 years in HR and 10 years in the PEO space. In my current role here at G&A, I partner with clients to manage ADA compliance and employee accommodations. My background spans employee relations, compliance, and leave management, and I'm also a member of the LOA team here with Desiree, and I've been with G&A since November, so about 6 months.
Awesome. Thanks, Kimberly. All right. So to kick us off, can you walk us through a quick history of accommodations, how they began, and what does the landscape look like today?
Sure.
Thanks, Desiree.
Sure. So the Americans with Disabilities Act, or the ADA, was signed into law in 1990, and it really stemmed from decades of grassroots efforts to advocate for people with disabilities, particularly in the workplace. And what that law does, it prohibits discrimination based on disability, and it requires employers to provide reasonable accommodations to an individual so that they can enjoy the same employment privileges. So when you think of ADA, what comes to mind? You may think of wheelchair ramps or the automatic door openers to get into a facility. Those are the things that may come to mind. But as we progressed, both technology-wise and as neurodivergence is better understood, we are starting to see those unseen disabilities that require accommodations in the workplace as well. So for disabilities such as ADHD, anxiety, sensory issues, we start to see the workplace evolve in a variety of different ways, creative ways to accommodate those folks in the workplace. And as far as who this applies to, it doesn't apply just to current employees. This is a law that spans the entire hiring process. So the application process, the pre-employment process, the hiring process, including interviews, any kind of pre-employment practices, all the way through the actual employment tenure of the employee. So this isn't just a one-time only while they're working. This is basically from the beginning to the end of an employee's tenure with you.
Which employers need to follow the rules of ADA?
Sure. So employers with 15 or more employees are required to comply with the ADA. Now, that is for the federal statute. There are some states, particularly Texas, Colorado, I believe California is also another one, where their threshold to comply with a similar law to the ADA is a lot lower. It's 1 employee or 5 employees. So we're talking about the federal statute, but there are some states with a lower threshold.
Thank you. That is great to know. So jumping in just to the next question, still staying on accommodations and ADA, what bare minimum documentation policies or internal processes should every employer have in place before accommodation requests arise? Or are there any?
So before an accommodation request arise, every employer should have at least a basic framework in place, right? Clear policies. They need to have defined roles. We always recommend clients have job descriptions in place and a simple documentation process. They need a way for the employee to request. They need a process for the interactive process, documentation, and they need a follow up. They need to have documentation of whether they're approving the accommodation or they're denying it, and what all of those steps include are documentation. And we always recommend handling it consistently, promptly, and in compliance with the ADA rather than reactively.
I know we talked a little bit about, accommodations and accommodations being reasonable, right? How does a company decide how a request is reasonable?
So for that, they need to engage in the interactive process. And there are several different kind of arms of that, right? They need to confirm that there's a qualifying disability, and that could include requesting medical documentation from their employee. Then they need to identify the essential functions of the job. So the accommodation needs to address the essential functions. And what helps with that is a thorough job description that lists those essential functions. Um, then they need to understand the functional limitation at work. So how the disability then equates to the job description, and then ultimately how that is defined through what limitations there are at work. And then once they have the better understanding of those, they need to evaluate whether that requested accommodation is effective. So the employer evaluates whether that request would be effective, meaning it would allow the employee to perform the essential job functions. Um, and then after that, once you have all of that in place, you need to access and look through undue hardship. And we'll talk a little bit more about that in detail. But even if an accommodation is effective, the employer has the responsibility to consider whether it would create an undue hardship for their business. And that could include significant cost, operational disruption, safety concerns, or the ability to meet business needs. So all of those things have to be put in place for the interactive process to be effective in this.
So I know sometimes employers view the first 90 days as almost a probationary period for employees. So let's say an employee comes forward with an accommodation request during the first week. Should they treat that any differently?
Actually, the answer would be no. So the ADA applies from an employee's very first day of employment. It even applies before they're employed during the application and interview process. So there's no exception for probationary periods or first 90-day periods. Employers still must evaluate requests and engage in the interactive process from day one.
Great. Thanks, Kimberly. I know there was mention of undue hardship. Can one of you please clarify what that means and how should employers document undue hardship? Would like to
Sure.
think.
Sure. So undue hardship or undue burden is a legal standard. It's not a matter of inconvenience or as an employer not wanting to put into practice and implement an accommodation. Undue hardship is a legal standard, and that is defined as significant cost or difficulty to the employer or business operations. And that is the one legal standard that an employer can, in some cases, utilize to forego implementing an accommodation because it's not reasonable based off of that legal standard.
So temporary accommodations, what are they and when can they be used? What should they be used for?
Sure. So, temporary accommodations, you can think of those as short term adjustments put in place that can support an employee while you are gathering more information and while you are waiting for maybe some medical documentation to be submitted. So, you can temporarily allow an accommodation while going through the interactive process to address immediate needs. You can test effectiveness or avoid unnecessary delays while evaluating long term solutions.
Now, is there a certain period of time where an employer would have to accommodate a request?
in terms of how long it should take for them to implement an accommodation. The idea is to hopefully get an accommodation implemented quickly, but we want to make sure that you're taking your time while you're evaluating what the accommodation, what the disability is, what the accommodation proposed is, and is that going to be effective? Um, when we say temporary accommodations, we get asked a lot, well, doesn't that setting a precedent for the future? And it doesn't necessarily set a precedent. That's the reason why it's temporary. It's temporary in nature to allow us, as the employer, to obtain the necessary information, whether that's a medical certification of the physician, to verify what difficulties they might be having on the functional level. And it also allows us to not have to put that person on a leave of absence while we're waiting that information. If we can keep that person working, even if it's on a temporary accommodation, that would be ideal. We don't want to take them out of the workplace. The goal that we like to tell our clients is the goal is to keep the person working, the individual working, keeping them on the work site. The goal is not to take them off of work, put them on a leave of absence. The sole goal is really to make sure that they're continuing to be able to work on the work site, however possible that may be.
Awesome. Thank you. That is super insightful. And actually, Desiree, speaking of leave of absence, can a leave of absence actually be considered a reasonable accommodation? And if so, are we always required to accommodate that request?
I'm going to answer that in two parts. So I'll take the first part of, can a leave of absence actually be considered a reasonable accommodation? That answer is yes. Many times we see this put in place after either a state mandated leave, FMLA, PFL, those things exhaust. Then we're entering into a realm of considering that leave, if it needs to go further than the 12 weeks or however much time they get. Do they have to consider that as a leave? Yes, they need to enter into the interactive process and consider whether that additional leave would be able to be accommodated, or does it then result in an undue hardship. So same process as we talked through before. We have to consider a leave just as we would as a stand-up desk or, maybe headphones, anything like that. So it's the same concept that they need to consider and go through the same steps. Does it always mean that you're required to accommodate that request? It does not. A leave of absence can be a reasonable accommodation under the ADA, but it's not automatic or unlimited. Employers must evaluate whether the leave is reasonable in length and whether it enables the employee to ultimately perform the essential functions of the job without causing undue hardship. Hope that helps answer that.
It does. It does. Thank you so much, Kimberly. So I know these days we are hearing a lot about remote work or hybrid work as a potential accommodation. How do employers navigate the growing perception that remote or hybrid work accommodations are being the default, right? Or the end all be all solution for accommodation requests?
Yes. So we see this often, especially now with neurodivergence becoming something that's brought up more often in the workplace that needs accommodation. And the answer that we always, I think, provide to our clients is it's not the be all end all. Remember, as the employer, you don't have to select or implement the accommodation that the employee prefers, right? Just because they want to work from home and they think it's going to be, beneficial to them to get rid of distractions or for it to be a lot more quieter that they're working at home, that doesn't necessarily mean that it's the best accommodation. So with that said, we always look at the medical certification. Implementing these is really medical certification driven. It's not employee driven. So the employee may be feeding information to their doctor. I want to work from home, let's say this, but at the end of the day is what are their essential job functions? What functions that are essential are they having trouble performing? And what can help them perform those functions? Working from home may not be the first thing that we're going to jump to. Headphones, noise canceling headphones might be one. Screen readers, depending on what kind of disability they have, whether it's sensory issues, migraines, things like that. We want to look at what can we do to keep them at the workplace that is also reasonable, that we can implement at the workplace with minimal cost and without significant difficulty. Now, are there situations where work from home or hybrid work environment is best? Yes, but it's always usually kind of looked at as a last resort unless we cannot find anything else that allow this person to perform their work efficiently and with the essential functions. we usually look to that last.
I'm hearing this is kind of where the interactive process might become very important.
Yes, yes. We
Awesome.
see a lot, particularly with people who may have, you know, difficulties concentrating or with focus. They want to close their doors or they want to work from home because they think it's going to be much quieter. And we've found in working with some of these clients and the employees is that noise canceling headphones work just as well. Closing their door for periods of the day for what you could consider bubble time to focus on projects works just as well. There are a ton of different things that you can do in the workplace to make it more palatable for that person to be working in office instead of working from home specifically.
Awesome. Awesome. So let's talk a little bit about managers and their responsibilities. I know sometimes managers, they are the first point of contact for employees. So what role do frontline managers play in staying compliant with accommodation requests?
They play a critical role in the ADA compliance, because like you said, they are often the first person to hear about accommodation requests or noticing that an employee is having difficulty with some of their essential functions. So it's critical that they are trained in this process. So one, they can recognize, and two, they know how to follow through. Um, you know, making sure that they have the ability to recognize, escalate, and avoid shutting down requests essential to a compliant interactive process.
Thanks, Kimberly. And then let's switch gears a little bit and talk a little bit about confidentiality and internal culture. How do I explain to an employee's um, new special treatment? So let's say we have an employee that has an accommodation, and other employees, may view this as special treatment, like let's say a flexible schedule. How do I explain to their coworkers without violating any confidentiality rules?
Yeah, I think at the end of the day, you don't have to go into too much detail because it's not their business in the kindest way because you may be divulging, information about their disability or medical. So there are a variety of ways that you can kind of temper that down a little bit, and you can just say, look, I can't discuss someone else's arrangements with you, or this has to deal with something medical, and unfortunately, I can't divulge that information to you at this time. Or I've seen clients say something to the effect of, it is confidential, and just as I would protect your information, whatever's going on with you confidentially, that's what I'm going to do in this employee's circumstance as well. Obviously, a little bit more curt than you may want to be, but sometimes you have to be a little bit more direct with people because they will try to get as much information as they can out of you. But at the end of the day, it's confidential information. It's not special treatment. This is merely an arrangement so that they can perform their job efficiently.
Great advice. Thank you, Desiree. What's an accommodation mistake that you see small and mid-sized employers make regularly, and how can they fix it quickly?
So, one of the common mistakes that we're seeing with small and mid-sized employers is they're waiting too long or treating the accommodation request informally. They're having casual conversations or they're saying, sure, we can let you do that, instead of making sure they enter into the interactive process. One of the most important steps in all of the ADA process is documentation. Everything has to be documented. It has to be witnessed. It has to be communicated in an effective way so that you don't misstep. And you don't have an employee saying, well, they promised me this, or they allow me to do this, and then another manager comes in and says, no, we don't allow you to do that. So documentation and engaging in the interactive process is the best way to keep those missteps from happening.
And if I could add, another thing to keep in mind is that there are no magic words. There, there aren't any words that signal to the employer, okay, we have to do this process now. It's anytime you get an indication, an employee indicates to you that they may be having trouble performing their job. So that could be anything from, man, this medication is really, giving me a lot of really weird side effects. I'm having trouble, remembering things or typing things out as quickly as I used to. Or it could be, this this machine that I'm working off of, let's just say, for instance, they are, janitorial at a healthcare facility, and they're using a floor scrubber. They may say, man, this scrubber really hurts my knees when I'm trying to push on it for 8 hours a day. It's really tough. Those are the things that as a frontline manager, you want to be listening for. Now, that's not to say that we want to run to the employee at every single little, ache and pain, but if someone is telling you or indicating to you that they're having a problem doing this particular job task because of something that seems to be medically related, that's when you want to pull them to the side and have that conversation with them. And it's not really even it's a dialogue, right? It's just an open conversation between the manager and the employee. Is, hey, you mentioned that you were having some trouble. Can you tell me a little bit about what's going on? And they may decide to open up and say, well, you know what, I hurt my knee last week, and so that's why it's really tough to do it this week. Or they may indicate that there's another more chronic medical issue that needs to be looked into as far as providing an accommodation for. They don't have to come out and say, I need an accommodation. They can say other words that allude to the fact that they may need some assistance.
Yeah, I think that is so important. Like you said, employees don't necessarily need to say the word accommodation. Employers still need to watch out for those keywords in order to start that process, that conversation with that employee. Thank you. That was incredibly helpful and insightful. All right. So, next question. So, how do employers define what is truly an essential function when job roles have evolved over time?
Absolutely. This is where it is extremely important to have your job descriptions updated. You should be doing those annually, anyways, but this is this perfect example of why those descriptions should be updated because that will have what the essential functions are, especially if that position and those duties have evolved over time. And when we're talking about essential functions, we're really wanting to look at what's that defined as. Well, that is defined as that this job exists to perform that function. So, for example, the job of a cook, it exists to cook food, right? Very simple. We also want to look at the function. Does it require specialized skills or expertise? The person is hired specifically with that skill, with that expertise. And we also want to look at, are there only a limited number of employees that are there that are hired to perform that function? The essential functions are what make that position go, if you will. Talking on the phone could be a function of all of our positions, right? But what is the essential function of my job as an HR advisor on the LOA team, right? I'm helping with the complex case. I'm helping with, run clients through the interactive process. That's my essential function. But there may be something else a part of my job that's not essential, but I do it, but it's not essential. So if that was not part of my job description at any given day, that would be fine.
All right. Thank you, Desiree. I'm hearing that just keeping those job descriptions updated is incredibly important.
Mhm.
What does a good faith interactive process actually look like in practice?
I will take that one. So, in practice, when you're engaging in the interactive process, it means it's an open dialogue, it's an exploration of alternatives and clear communication, right? It's meant to be collaborative and decisions should be documented and explained, right? You have to, during the interactive process, you have to confirm that that employee does have a qualifying disability. You have to first confirm whether there is that under the ADA, it's physical or mental impairment that substantially limits a major life activity. That's per the definition of the ADA. This may include asking for medical documentation. So that's part of that interactive process. So you get the request from the employee, you have a conversation with them, you decide, yep, it's time for us to enter into the interactive process. As we mentioned before, there's no magic words, there's no magic, phrase that the employee is going to say. Maybe you've noticed that this employee is having trouble meeting some of those essential functions. You have that conversation, they decide to share with you that they've either started new medication or, yes, I have trouble because of XYZ, then it's time for you to enter into that. So they have communicated to you, you meet with them, you document that you're requesting them to return. We use an ADA accommodation medical cert. So that medical certification comes back and it explains what should happen is the doctor looks at your job description. looks at the essential functions, and outlines what, if any, accommodations can be put in place or requested that could help them perform those essential functions. So that is the next step. Once you get that paperwork back, the employer is going to look at it, they're going to review, and they're going to see what can we accommodate. Maybe not everything, maybe not all bulleted points that doctor sends you, you can accommodate, right? Let's say it's asking for more frequent breaks, or it's asking for a stool at their work location. Maybe they can't stand for long periods of time. Maybe they can't walk long distances. All of those things, and you take each of those and you consider whether you can or cannot accommodate those. Sometimes it's an easy fix like a stool. Sure, we can allow someone that works in an environment that maybe they need a stand-up desk versus a sit-down desk. Maybe they have the equipment there that they could raise a desk, or can they buy a stand-up desk that someone can use, whether it's permanent or temporary. So all of those things are considered. They go through the bulleted list. Then they understand. That helps them understand the functional limitations, right? And then it understands what the doctor is suggesting that they need. And then once that happens and they've met with the employee and they've documented everything, then you should outline what they're approving. I always tell clients, and I'm sure Desiree does too, it's important that you have a time frame of when you're going to reevaluate. Is it working? Is it not working? Do we need to maybe make adjustments to these? Is this going to be something that we can put in place permanently? But you still should check in and make sure that it's, one, they're performing their essential functions and it meets expectations, and that those are valid accommodations that are going to be able to continue. So I always suggest they put a time frame in place, whether it's in a month, in 6 weeks, in 2 months. Check in with that employee, make sure that what you've put in place is working. And then sometimes if it's a temporary, put that end date that you're going to approve this through this date. If it needs to extend, we may need additional documentation submitted.
Thank you so much, Kimberly. I think it's incredibly helpful for us to have or listen to those steps in the interactive process and what we should be doing with employees that do have these accommodation requests or needs. So, what risks do employers face by not following the interactive process?
I will take that one. So the first and probably most obvious is your increased liability under the ADA, right? Failing to engage in the interactive process can itself be evidence of a disability discrimination. Even if the accommodation might not ultimately have been reasonable, if you don't enter into that interactive process and document it, then you have no documentation that you entered into it. Employers can be found that they failed to accommodate. The EEOC could have, complaints filed with them for process failure, right? Not intent, but you did not follow the process. An employer doesn't win an ADA case typically simply because the accommodation was hard. They have to show that they tried and entered into that good faith attempt of an interactive process. Sometimes the employee does not also enter into that good faith effort. They have to do it as much as the employer does. They're responsible for entering into it as well. That's why we call it an interactive process. If the employee is ignoring the employer or not submitting documentation or not having those conversations, then that is another avenue that they can take. Unfortunately, we attempted to enter into the interactive process, but the employee refused. Documentation gaps work against employers in these instances. You want that documentation. You want to show that you entered it. And you don't want to show any type of documentation that you automatically just denied the request. You automatically said, no, we can't accommodate that. I'm sorry, we're not going. Entering into it, even if you know the answer more than likely is going to be a no, you have to show those steps. That is a good faith attempt in entering into the interactive process.
I know there's a saying, Kimberly, if we did not document it, it did not happen.
Very true. True.
Oh. And that's from both sides too, not just the employer engaging in that good faith effort, but the employee as well. They're the ones that want the accommodation. And so just saying, I need this accommodation and walking away is not engaging in a good faith effort in that interactive process. They are required to be active participants in it.
Mhm. Even though employers are not required to approve every request, they are required to engage in every request.
Thank you both. Very insightful. How much documentation is enough without creating unnecessary barriers in the interactive process?
The medical certification is the best form of documentation probably that we could receive because it's usually consistent. When we're asking for supporting documentation to help us determine if an accommodation is reasonable or even needed, we don't want to hear about diagnoses. We don't want to know what the employee's diagnosis is. We don't want to hear any of that. We just want to know what functional limitations do they have. That's one, I think, downside that some employers will want to know, well, what do they have that makes them not be able to do X, Y, or Z? We don't need to know that. We just need to know the functional limitations for that employee. So how much is too much documentation? We shouldn't be asking them for, a new certification every week if we're still working on approving and reviewing the first set of medical documentation that we've requested. So usually the first medical certificate that comes back is enough. However, if there are still questions about what those functional limitations are, and if there's even questions about how long they're going to last, because remember, sometimes accommodations aren't permanent, sometimes they're just temporary. So we want to know that. We don't want to just know what's the limitation. We want to know how long is this limitation expected to last? Is it permanent? Is it temporary? And if it is temporary, what is that time frame on it? So we don't necessarily want to be asking for a ton of documentation, just that medical certification, and then being able to follow up with the doctor if there are additional questions on those limitations.
Thank you, Desiree. Uh, just a follow-up question with that. If an employee's accommodation changes, is it appropriate to ask for medical documentation again at that point?
It really depends because, again, we don't want to go documentation overload. If the condition that they're requesting an accommodation for is not one that we have information for, that we don't know the limitations for, then yes, you're probably going to want to ask for additional information on that medical certificate. But if the medical certificate or the documentation that we already have has that information on it and can tell us what those limitations are for this other perhaps medical condition or potential accommodation request, then we don't necessarily need a whole other medical certificate.
Thank you. How should employers evaluate an accommodation request when there are legitimate safety concerns? Who would like to take that?
I'll take that.
Kimberly? Awesome.
So, under the ADA, an employer may deny an accommodation only if it would pose a direct threat or undue hardship, right? The undue hardship we've already talked about. But direct threat, what does that mean? So, it's a significant risk of substantial harm to the employee or to others that cannot be eliminated or reduced by a reasonable accommodation, right? Speculation, assumptions, or generalized fear are not enough. So, I'll give an example. If someone is working in an environment with machinery, and maybe they recently were diagnosed with epilepsy or something, right? That significant risk of safety would mean if they passed out or if they, fell or anything like that, they're around machinery that could, one, hurt themselves or could hurt their coworkers. So that is one that you want to be very careful. You really can't accommodate someone being in that environment if it's going to pose significant risk of substantial harm. So that may be moving them into an office environment, having them help with filing, or temporarily having them move out of that environment where there are safety concerns. And that's just one example. Before denying an accommodation based on safety, employers should, take a look at the specific safety risk, the severity of potential harm, the likelihood that that harm would occur, and whether the risk can be mitigated with adjustments. So what can they put in place to keep that employee and their coworkers as safe as possible? The interactive process must still be followed. It's still required. Just because you have that type of environment, your working environment is such that it does have machinery or things like that, that does not equate to immediately saying it's a safety risk. I'm not even going to enter into this. It's a no. You, employers still have to enter into the interactive process to see if there is a position that they could temporarily move that employee into that would not pose the same safety risks.
Super helpful. Thank you, Kimberly. How does the Family Medical Leave Act, FMLA, and ADA interact with one another?
So I'll take that one. So the Family Medical Leave Act, or FMLA, and the Americans with Disabilities Act, ADA, are two separate laws, right? They do often overlap when an employee has a medical condition, but employers must evaluate both independently and apply whichever provides greater protection to the employee. So the FMLA, as we all know, provides job protected leave up to 12 weeks in most cases. It applies to eligible employees at covered employers. It's about time away from work. Leave is generally unpaid, and it has a finite entitlement. Where the ADA requires reasonable accommodations for qualified individuals with disabilities, it applies regardless of length of service. It's about enabling an employee to return to work or continue working. Accommodations can include leave, but also flexibility or job modifications. There's no fixed time limit on an ADA. So the key distinction is FMLA is about leave entitlement and ADA is about access and accommodation. I do want to touch base quickly on what happens when FMLA ends. So once FMLA is exhausted, the employer needs to ask, does the employee have a disability under the ADA? Is additional leave or another adjustment needed for them to return to work? And would that accommodation be reasonable and not cause an undue hardship for them to either extend that leave for a little while longer or consider an accommodation for them to return? What the ADA does not, and they're very clear on their definition of this, it does not mean an unending leave. There needs to be dates associated with their leave request to extend when the FMLA exhausts.
That is great to know. Thank you so much, Kimberly. I think a lot of employers have that question. Okay. So, question, is there an example of how an employer avoided a big compliance mistake, and what did they do right?
Yes. So I had worked with an employer about a year or so ago. Very big office, can be a little bit loud, noisy. They dealt with medical billing and ambulatory transportation and things of that nature. And they had an employee who was really struggling to meet the demands of the data entry aspect of their job just because they said it's just too noisy, it's just too loud. And they had originally asked to work from home because it would, in their eyes, mean less distractions, it would be quieter. Before the employer moved to that accommodation, they said, well, let's try some other things that you kind of brought up that work. So this employee had previously talked about how when they're on public transportation, they'll use the noise canceling headphones. It kind of keeps them in their zone and they don't feel as anxious about writing. And so the employer worked with that employee to determine, hey, can we buy you noise canceling headphones, or can we put up a cubicle so it's a little bit higher and you're not seeing people walking by and seeing those distractions. And it actually ended up working out really well for that employee. So much so that other employees who had the same kind of neurodivergence with ADHD and troubles focusing, it gave them the confidence to be able to come forward as well and say, hey, listen, I'm also having this problem. I didn't think you guys would care or listen. Can I try something like this as well? And so you've got a couple of employees in that office now who have the noise canceling headphones and who maybe have moved their workstation a little bit so that they're not seeing everyone walking by, and they are now meeting and exceeding those expectations for their position.
Awesome. Thank you, Desiree. I appreciate that. Thank you for sharing. It's always good to hear a real life situation and how employers have managed through that.
It's what it's all about. It's about listening, not making assumptions, and being collaborative when it comes to situations like this.
Wonderful. Okay, so in the interest of time, before we get to attendee questions, I do have one final question. If employers remember just one takeaway from today's conversation, what should it be?
Oh, I would say to listen, not just hear what employees are telling you, whether it's in your one-on-ones or group meetings. Actually listen to what they're telling you if they are indicating in some shape, way, or form that they're having trouble performing the essential functions of their job, and if they're indicating that it could potentially be something medically related, then you definitely do want to have a conversation with that person. It doesn't have to be super serious and formal, but you do want to at least pull them to the side, have that conversation with them, and ask, what do you need in order to help, be able to perform the essential functions of your job? If anything, it may just be a tough day. It may be something where there does need to be an accommodation made, and that's when you go into the interactive process and documenting, what accommodations have been suggested, what have been approved, obviously obtaining medical certification. But I think that's the biggest takeaway is just listen. Just listen, because a lot of times we see it come back around and like, well, they didn't really tell us. And we're like, well, this is the text that they sent you. They said, I am having trouble. So really just listening to your employees is the biggest thing that you can take away from a conversation like this.
Makes sense, Desiree. Thank you so much. We received a couple questions from attendees that we wanted to provide answers to. So I'm just going to look at these. Here's a good one. So Jamie from Denver asked, can you clarify how employers should handle requests for emotional support animals as a workplace accommodation? Specifically, what documentation can be requested and how should we balance this with concerns like allergies, safety, or other employees' comfort? Who would like to take that one?
I'll take that one. So I would like to first kind of differentiate the difference between a service animal and an emotional support animal. So, a service animal are typically dogs and sometimes miniature horses that are trained to perform specific tasks related to a disability. In that instance, those are trained to sometimes they help with someone who has a seizure. They can sense that it's coming and they'll tell them to sit down. So it's an example of what a service animal does. An emotional support animal are not service animals because they do not perform specific trained tasks. So under the ADA, an emotional support animal can still be considered a workplace accommodation under those definitions of the ADA. The analysis shifts from a service animal rules, which are very stringent on what you cannot ask and what you can obtain for that to allow those animals to come into the workplace, to the aspect of a reasonable accommodation framework. The interactive process still applies. When an employee requests an emotional support animal, the employer must engage and they first acknowledge the request appropriate medical documentation if needed, discuss how the animal would accommodate the disability, evaluate the effectiveness and the workplace impact, which, like you mentioned, are there employees that are allergic to this animal? You want to make sure that there's not other animals that are in the workplace that could cause issues. Then, if those types of things cause an issue, consider alternatives. Document the process and the decision. Automatic approval or denial will always cause risk. So you want to make sure that you are entering into that interactive process. I can give an example of we had a client who has cats on site because of the nature of their business. The cats help with rodent issues. They had an employee who would like to, come in and use an emotional support animal. As long as that emotional support animal does not interact negatively with the cats or they can kind of separate them, they were able to accommodate that. If there was going to be an issue with the dog not being able to be around the cats, then they would have needed to look at alternative, maybe different locations, or maybe allowing that employee to take more frequent breaks, right? Always looking at what those alternative accommodations could be. When an employer receives a request, They want to make sure that they follow the same interactive process. Is there a qualifying disability? What does the animal help with that functional limitation? And how the animal helps manage symptoms related to work. What employers cannot ask for a diagnosis, that's the same with all interactive process. Demand certification or registration papers. Emotional support animals do not need to have those to be brought into the workplace. And they also cannot require proof of training, since emotional support animals are not trained service animals. So the focus needs to be on functional need, not the animal itself. Hopefully that helps.
It does. A lot of great information. Thank you so much, Kimberly. If our company doesn't typically allow remote work, how should we respond when an employee requests to work remotely as an accommodation?
I'll take that one. So a company doesn't automatically have to allow remote work, as we mentioned earlier in the webinar. If the job genuinely requires on-site presence for confidentiality or essential duties, they still have to enter into the interactive process and look at all options and talk through what options are available, but it doesn't necessarily have to be an automatic, yes, you can work from home, especially if they're looking at those types of concerns with their business operations. For example, if someone needs an accommodation for noise reduction, like Desiree talked about earlier, um, you know, maybe they were recently diagnosed with hearing loss and they are getting used to hearing aids or some other device. An option could be to find an office that they could move into, so they can shut the door for quiet. Or if there's not an option for an office that's available, maybe purchasing them noise canceling headphones, as we mentioned. That's always things that you can consider. So it's not necessarily one of those things where you can just automatically say no, but you do have to look through everything, all the options, and talk about it to see if there is a better option or a more viable option. And then if you can't offer any of those types of things because of the working environment, maybe they're in a warehouse type of situation and maybe they do paperwork. And maybe that can be done at home. It doesn't cause any safety concerns or confidentiality concerns. So they should consider that. Even if they don't let others, still considering that is part of the interactive process.
We like to look at it as we're not allowing someone to work from home simply just to work from home. If someone's going to be working from home under an accommodation, it is for that reason, for an accommodation, not because it's special treatment or anything like that. And so we try to keep our employers, our clients from saying, well, we don't let anybody work from home, because at some point you might have to let someone work from home as an accommodation under the law.
Perfect. Thank you both. And I think we have time for one more question. So this is from Jennifer from Salt Lake, and she is asking, as an employer, if we do not agree with the accommodation request recommended by a medical provider, can we get a second opinion?
I will take that. In very, very limited circumstances. Most of the time that answer is going to be no. Under the ADA, even though employers don't have to automatically agree with a doctor's recommended accommodation, they also don't have a formal second opinion process like they do with the FMLA. So if the information is unclear, the best approach is to ask for clarification from that doctor and continue the interactive process to identify an effective, reasonable accommodation. It's why it's called interactive. It's kind of a back and forth conversation type of process where you're talking with the employee, they're going to their doctor, and then it's a back and forth. And that could take a couple times for you to get to a place where that accommodation can be put in place.
Perfect. Thank you, Kimberly. We are just about out of time. Desiree, Kimberly, thank you both so much for a thorough and insightful conversation. You really showed why having a clear accommodation process is crucial for employers. And thank you, everyone, for spending your afternoon with us. We hope this webinar has provided you with the tools you need to manage accommodation requests confidently while supporting your employees. We wish we could have reached every question in the Q&A. If we did not get to yours, a member of our team will reach out to you directly, and we'll follow up with details about the continuing education credits as well as more resources to help you. You'll also receive a survey about how we did today. If you can take a couple of minutes to fill this out, we greatly appreciate your feedback. It's how we make sure these webinars give you the tools you need to grow your business and stay in compliance. Thank you again for joining us. We look forward to seeing you at our next webinar.